podcast is provided for informational and educational purposes only and should not be construed as legal advice. Because every situation is unique, you should consult with a qualified legal professional for advice specific to your circumstances. If you need legal guidance, please reach out to an accredited attorney or contact us to schedule a consultation. Hello, and welcome back to the Veteran Benefits Podcast. I'm your host, Rebecca Deming. Today, we are going to talk about how to win your VA case if you don't have new and relevant evidence. So, we've talked about in prior podcast episodes, there are a few different appeal options now under the Appeals Modernization Act, which came into effect in 2019. So, since then, people can choose a supplemental claim, which requires new and additional evidence, new and relevant evidence related to their condition that proves a piece of the, or tends to prove, speaks towards an element of the claim that has not yet been established. Or you can do a higher level review, or you can go to the board. And at the board, there are also 3 lanes of appeals. You can do a direct review lane, which we'll get into in more detail. You can do an evidence development lane where you do submit new evidence. It just goes up to the board. And you can do a hearing lane. And with the hearing lane, that takes the longest because you're waiting to get on the docket to actually speak in front of a judge. And then after the hearing, you can add additional evidence if you want. And there's a specific window. We'll talk in future episodes about the window of adding evidence and kind of the use cases for a hearing lane appeal at the board. But right now, we want to talk about what to do if you have sent in VA everything that you think is relevant for your case and VA still denies the claim. So you have service treatment records, you know something happened in service, or it's a presumptive condition. You've sent in medical records showing that you have a current diagnosis for this condition. Maybe you've also sent in a nexus letter, or you went to the CMP exam and the examiner told you, oh yeah, that's connected to service. That's going to be a no-brainer. And then mysteriously you get this denial letter from VA that says that the condition is not service connected. In those cases, I know there's other forms out there. I've heard misinformation. I've heard a lot of veterans say, well, I was told just to refile the claim. It's going to be faster if I just refile the claim. VA should kick back the claim if you file on a new claim form instead of filing it as a supplemental claim. But it also doesn't preserve your earliest effective date. And if you've already sent in everything and VA is overlooking critical evidence or critical facts in your case, resubmitting the same evidence or getting another nexus letter that says basically the same thing in different words is sometimes not what you need in your case. What you need is to show VA that they didn't apply the right rules or laws to processing your claim, that the evidence that they need is in the file, they overlooked something, point out what they overlooked, and make arguments. Sometimes there's case law arguments, sometimes there's, nowadays you can use Google. Often if we get to this level, this is when I do recommend getting an accredited legal professional, a claims rep, or an accredited attorney involved in your case, because these nuanced legal arguments can be very nuanced. So if you don't have additional evidence, or if you feel like you've sent in everything else, your 2 options are a higher level review or a direct board appeal. So I'll talk about both of those options now. The fastest one is a higher level review. And you fill that out on VA Form 200996. That's 200996. And you can submit argument, but you cannot submit additional evidence with that. So you can put together a brief or a statement about what you think VA got wrong, or you can just fill out the form. It's a 3-page form. It's pretty simple. And you can request an informal conference with the decision review officer. A decision review officer is not an attorney, typically. I guess there's nothing to stop VA from hiring attorneys, but by trade, they're not attorneys, but they are senior reviewers, typically been with VA for a few years. They've gotten good performance reviews, and they've moved up the ladder. Does not mean that all of them are perfect by any means, but they tend to have a better understanding of the regulations and ability to look through the evidence than the more junior raters who will do the initial decision sometimes. So if something got missed on the first round, doing a higher level review, if you really do think you have all the evidence, can sometimes be a pretty quick way to get it corrected. For the most part, we see higher level reviews currently at the time of filming in April 2026. They're taking about 4 months, unless your file is flagged for hardship, if you're terminally ill or homeless, or severe financial hardship. Sometimes VA will move stuff faster, but typically we're seeing them take about 4 months. Of course, that timeline fluctuates depending on VA's capacity and the systems they're using. But after about 4 months of waiting, it gets assigned to a decision review officer. Again, that's a senior rater. They look at stuff. They will schedule a call with either you or your representative to talk through the case. Again, you can't add new evidence at that point. So you can't say, well, I got another buddy letter. I got my doctor. I went to the doctor in between when I got the last decision and now, and the doctor's saying this. They're not going to be able to consider that. And they're going to just instruct you to file that on a supplemental claim. So then usually within a couple weeks of having that informal conference, which is optional, you don't have to. If you have everything on paper, you don't have to have that informal conference. But we find them helpful a lot of times to kind of put a voice with the claim and talk through some of the stuff that, some of the issues that might get missed in a pile of papers. And within a couple of weeks of having that conference, sometimes same day, sometimes a few days later, often it can take up to a couple of weeks, we'll see a decision issued from VA on that claim. Now, if you got another denial, you can relook at stuff and say, okay, maybe now it's time to add, maybe my nexus letter wasn't good enough. Maybe I do need to add additional medical records or lay statements to prove a piece of my case. You can go back and do a supplemental claim. It's not the end of the road. If they grant it, that's great. VA will issue you your back pay and issue your award going forward. The other thing that comes out of a higher level review is what VA calls a duty to assist error or difference of opinion decision. And they're technically two different things. VA sometimes uses them interchangeably. But basically what that is VA saying there was an error in the original decision. There's not enough in here for me to grant it and assign a rating. So we're going to send it back to get additional evidence. It's usually another medical opinion or medical exam. Sometimes they're going to ask for a TARA memo, a toxic exposure risk activity memo, or for VA to go back and pull additional records that were missing from the file. Different government agencies have to coordinate with each other. So sometimes if there are records missing from the file, VA will send it back with instructions to correct those. And you'll get that opinion or that decision that doesn't have a lot in it. Basically, it says VA found that there was a duty to assist error. We're sending it back to correct that error and gather more evidence. We'll issue another decision. You don't have to do anything at that point, technically, but you're kind of back in the evidence development phase. You're back with the original cadre of people who made the first decision. So we do see a lot of errors after stuff gets sent back to correct a duty to assist error. And theoretically, you could go in that circle indefinitely. You could get a decision, file a higher level review, get a duty to assist error. They send it back, do some development. You don't like that decision, you can file another higher level review, argue with the decision review officer. You can go around in that circle indefinitely if they're not correcting the errors. So there's a lot of strategy into looking at what VA is getting wrong and what the capacity of the people are to understand how complex a certain issue is, and maybe decide to take it up to the board at a certain point. So if you don't have new evidence, you can go higher level review. You can also do a board appeal direct review lane. The board has board judges or board members, but we informally call them judges. And they have staff attorneys who review stuff and write the opinions and then give it to the board judge for them to sign off on. So you do have people with typically a higher level of training, higher level of education, reviewing the files, who understand more complex rules or are able to parse apart the complex regulations. So VA's gotten stuff wrong a number of times at the regional office level. Sometimes going up to the board is really helpful to get it in front of somebody who understands the laws a little bit more clearly. Oh, well, there's a few things to understand about going to the board. One is it's almost definitely going to take longer than filing a higher level review to get your decision. Now, I would rather wait 1 year or 18 months for a good decision than be in this cycle at the regional office if I just don't think they're going to get it right at the regional office. And there's certain issues where even the regional office staff will say, hey, we don't have the authority. It's interesting. It's like, we don't have the authority to actually follow the law. You're going to have to send that up to the board to get a decision, but we understand what you're saying. So sometimes there are certain things that we just know we're not going to get the regional office to grant, but we are likely to get a grant at the board. But you are likely going to be waiting about a year for a direct review. Some of them have taken much longer. The board is speeding stuff up, and we're seeing stuff typically take about a year right now, unless it's advanced on the docket. So if you're over 75, the board will advance your claim on the docket. If you can put in a motion if you are homeless, at risk of homelessness, severe financial hardship, terminally ill, and the board will issue a determination whether to advance your claim on the docket. In order to get that advancement on the docket, to actually, once they grant it, in order for them to actually process it that way, you also have to send in what we informally call a switch waiver. You have to send in a one-page form saying that you're waiving your right to switch appeal lanes. So please, board, just go ahead and make the decision. We promise we're not going to try to go back on it and switch our option, choose a different appeal lane. Because if you don't send that in, the board will wait the full year from your prior decision to issue a decision on this, because you have a year from your prior decision to switch appeal lanes. So if you file a board appeal and then you say, actually, I'd rather do a higher level review, you have the option to switch. Or if you file a direct board appeal and you want to switch it to a hearing lane or evidence development lane, you can switch lanes. So that switch waiver is important because it kind of allows the board to actually put your claim into the advancement on the docket lane and process it faster. So with our veterans who are in those situations, if they're 75 or older, or if they have financial hardship, sometimes we'll just avoid the higher level review lane altogether and go direct appeal to the board, because the board might make a decision in about 4 months, similar time frame to higher level review. And we've got a more highly trained, highly educated class of people reviewing the decisions. Now, that said, the board does have pretty high turnover of their staff attorneys. And so when it's a super nuanced area, looking at procedural history, they do have high workloads, and some of them haven't been practicing in VA law as long as we've been practicing in this law firm. So sometimes going up to the board still doesn't get stuff right. And in that case, we have the court above the board, and we can talk about that in other episodes too, the role of the court in what it means if we appeal a board decision that we're not happy with to the court. But typically, if you go direct review option to the board, you can and you probably should write up a statement about what you think VA got wrong in the prior decision. Send that into the board. You will not have, if you do direct review option, you don't have the option to, you're not going to have a hearing, so you're not going to be able to explain yourself. You're not going to be able to send in additional evidence. So even though the form itself, VA form 10182, is the board appeal form, even though it's a one-page form, you don't have to send anything else in. If you want to kind of tip the board off as to what you think the errors are and kind of steer them in the right direction, you're going to want to write up a statement or a memo explaining what VA got wrong. Again, that's an area where a lot of veterans decide to hire an attorney or an accredited claims representative, because figuring out exactly those nuances and phrasing your arguments in a way that preserves all of your appeal rights can be kind of tricky. And if you mess something up, you could be walking away from back pay that you would otherwise be owed. So that's one area where a lot of people get attorneys involved. So again, kind of to sum up, if you got a decision, you're not happy with it, it's usually not worthwhile just to go get another nexus opinion unless you identify that there's something missing in your first nexus letter. If you think there's missing evidence, you might want to do a supplemental claim. But if you really think that you put together a good package and VA is just overlooking something or misapplying the law, then you probably want to do a higher level review or a direct board appeal. So if you have questions, please put them in the comments section. Please like and follow and subscribe. And we look forward to seeing you on the next episode.